Welcome to the 5:30 p.m. November 14th special City Council meeting. We do have a quorum, so I'll call this meeting to order. Please join me in a moment of silence. And the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. City Clerk, please read the rules to speak.
Individuals wishing to speak on agenda items must complete a sign-up card prior to the item being introduced. Sign-up cards are available on the table in the council chamber. Comments made under public comment must relate directly to the agenda items. No sign-up card is required. Citizens will be given 3 minutes to speak on all agenda items. All sign-up cards and exhibits being submitted to City Council shall be placed in the box on the table in the council chamber.
Thank you very much, Ms. Emily. And City Manager.
2 items this evening. Good evening, Mayor, Vice Mayor, and Council. The first one is a successor agreement between the Labor International Union of North America and Local 630 and the City of Titusville. On 27 October 22, the city was notified that the contract ratification vote was held on 27 October and passed by a majority vote of 80-0. The collective bargaining agreement has been negotiated with the intent of achieving goals of the pay plan study for the city that has been conducted this year. Wages will be retroactive to the first pay period of FY23, which is 1 October, and a summary of the changes are part of your packet. Staff recommends that you approve the collective bargaining agreement between LIUNA, Local 630, and the City of Titusville.
Thank you very much, sir. Council, any comment on that at this time? I see none.
Yes.
Yes, sir. Go ahead.
It was great. The only thing that I could just wanted to curiosity, they went from 5 days in submitting a complaint to 10. And any particular reason they just decided that the 5 days wasn't long enough for?
Remember, you're referring to the grievance?
Mm-hmm.
Yeah, we tried to make it consistent with all of our contracts to give that time frame some consistency, and we felt that the 10 days was a lot more consistent with all of our collective bargaining agreements.
Okay.
So we just felt that equity amongst all agreements.
Okay.
Thank you.
Thank you.
Thank you very much, sir. Any other comments from council? I see none. Any cards?
No cards.
I'll take a motion. Vice Mayor.
Mr. Mayor, I move that we approve successor agreement between the Laborers International Union of North America Local 630 and the City of Titusville.
Second.
I have a motion from Vice Mayor, a second from Member Nelson. Roll call vote.
Member Robinson?
Yes.
Member Nelson?
Yes.
Mayor Diesel?
Yes.
Vice Mayor Jordan?
Yes.
Member Stokel?
Yes.
Passes unanimously. Thank you so much. Thank you for your efforts. And City Manager.
Second item is the engagement letter from Leonard M. Collins, Esquire of Gray Robinson, PA. On 12 July 2022, Council approved the acceptance of representation by Mark Logan, Esquire, of the Stiffen Smellman Law Firm to represent the city in a pending litigation regarding Speak Up Titusville's proposed charter amendment. This time, we'd like to submit council change with Attorney Collins of the Gray Robinson firm to replace the city's interest, to represent the city's interest in a pending litigation regarding the challenge to the right of clean water charter amendment and the subsequent appeal. A copy of the engagement letter is attached, and staff recommends that you accept and approve the engagement letter from Attorney Leonard M. Collins, Esquire of Gray Robinson, PA.
Thank you, sir. Council, any comments or questions? Member Robinson, you still lit up from last
Yes.
time? Okay.
With this is that how do you feel that this just coming up after the election or after the vote, be having 80% or whatever the percentile of the citizenry accepting it? I totally understand it and agree that the language was not specific. But what position does that put us in if, and now we are moving forward with something of this nature, that it has already been,
Correct. In my opinion, we're not moving forward. We're continuing. The declaratory judgment as amended exist, and we are continuing that litigation because under state law, you cannot put misleading information on a ballot. That is fatally flawed, and the courts will look at that. And we remember we weren't able to get a hearing before, so the judge wasn't able to hear it, so the language was on the ballot. So now we're having to argue it after because of the fact we couldn't get a hearing. So that case is just continuing. And the judge is still going to consider all the arguments with regard to preemption and with regard to misleading language on a ballot.
all righty, thank you.
It'd be my understanding in discussion with staff that it's just a continuation of where we were. And quite honestly, once it goes in front of the judge, we did our part by putting it on the ballot. That's what we needed to do. That was our job. I felt responsible, not responsible, but an obligation to make sure that we got that done. And I know you guys did, and we did. After that, it's, up to the judge to decide, first of all, if it is worded the way it needs to be worded, and if it is going to line up with the state, what's the word I'm looking for, legislation. Member Stokel.
Yep, I just want to clarify. I think that, I just want to be clear. We're adding the additional ballot language to what we were already trying to get an answer on, correct?
We originally filed right for being preempted by state law.
Correct, that's the,
Then we also have already added, and they've agreed to amend, so the pleadings have already been amended to include ballot language.
okay. So that's just an add-on to what we were
That's already been
already,
included.
okay,
This is just moving it forward to the court. We may decide we have to amend it further,
okay,
but that's what we will do. The key is to make sure this complies with law. Florida law requires that ballot language state the chief purpose of what they're doing and that it be understandable. If not, then, and that's statutorily mandated, and as the Supreme Court says, that if not, that's fatally flawed. And they cannot have voters voting on something that they're not aware of.
okay. So just to reiterate to council, I think my viewpoint and probably where you guys stand as well, even if this was before or after we had done nothing and it just got voted on, I think we're doing our due diligence
Absolutely.
to make sure that we are following law. Like, I think the ballot language was not correct in my opinion, but the real meat of it for me is, are we potentially putting something in our charter based on citizen vote that's illegal? And that's what I want to make sure that we're not doing, which I think that's what we're moving forward with.
That's the purpose of a declaratory judgment.
Okay.
It's the judge rule
Okay.
and under the law.
Thank you.
And I would again say back to council, we're not judge, jury, or anything else. We simply got it on the ballot. And when we start talking about what it says or what it does, that's really not our business. That's the judge's business. It doesn't line up with the state constitution. If it does, it does. If it doesn't, it doesn't. I would ask city attorney, is this also add to the fact that, or not to the fact, does this add that we are changing our attorney? Are we changing our attorney, or is this part of that?
Yes, what this is a substitute, and I think that this will serve our best interest.
Right. And that's kind of where I thought we were going. Some of the questioning made me feel like we're getting away from that aspect of it, so I just kind of wanted to get us redirected. I
And
believe,
this attorney has agreed to honor the same fees we were paying before, so it's not costing us any more, even though his fees are more than significantly higher regularly. He's agreed that he will keep the same fee we were paying, so it will not cost the city any more on an hourly basis to change counsel.
and being our city attorney, I like the fact that you would feel comfortable with this change, and that's what's important.
Yes, sir. I would also ask, I didn't mean to interrupt you.
No, go ahead. I'm sorry. I was moving along quickly.
I also meant to ask if there's a motion to retain this firm that you authorize me to sign the engagement letter,
Is this part of what we have here now? Are we adding that?
because my name is on the engagement letter. So I'm just asking you that I could sign the letter.
you can
Oh,
sign
yeah,
it.
okay, absolutely.
All
Think, again,
right.
I would say that's in your ballpark. And if you need any more, we'll get to that. Member Nelson.
Richard, do we have any idea about a time frame for some kind of court hearing?
Again, that'll be up to the judge. I can tell you that this is going to move very quickly.
Okay,
I suspect paperwork being filed tomorrow,
good.
and I will keep you apprised, of course,
Okay,
as much as I can. I know we don't meet again until the 22nd, but I'm hoping that a lot's going to happen between now and then.
yeah, because I'm like, we got a month and it's Christmas break and a lot of the courts shut down over Christmas. So
This
I'm hoping before,
this will be an aggressive stance
okay,
as far as timing. I shouldn't say that, but I meant trying to get things moving quickly.
okay, okay, thank you.
Vice Mayor.
Yeah, just a reminder, and I know this is about the attorney for sure, but I think it's good for us to discuss exactly what's going on here. And if you all remember, we tried to do this before it even got on the ballot. And the unfortunate thing is, and this is actually the nightmare that we didn't want, we felt that more than likely it would pass because just looking at the language, it said clean water. Who wouldn't want clean
Obviously.
water?
I wouldn't know who voted against it.
Right. So the challenge that we have, especially with the citizens, is we voted for this thing overwhelmingly, and now you all are trying to stop the will of the people. And that, in fact, is not true. But the challenge that we did have is by law, if the citizens garnered enough signatures, then by law, we were supposed to make sure it gets on the ballot. But we also had the precarious position of we feel that it's against the law based on what our city attorney is saying. So we wanted the judge to have a declaratory judgment before it got on the ballot. And unfortunately, he didn't have the time to do it.
Right.
Correct?
The struggle with that was we couldn't get a status conference with the judge until, say, Monday. It had to be to the supervisor of elections by Friday. And the other side was in trial, and judge said, I don't have 2 days to rule. He would not rule.
Right.
That,
And,
and we don't tell the judge what to do a lot of times.
Right.
So the judge said, I'll set a hearing later, but it'll be on the ballot. So
Yeah.
that's what we are. It's not as if now we're trying to attack something because of the result. This is
Right.
a continuation of what we started before it was even on the ballot.
yeah, and of course, I'm sure all of us got the email from the citizens saying, stop spending the money, you shouldn't do this. The people have spoken, and because we have sworn to uphold the Constitution of the state of Florida, we're doing exactly what we're supposed to be doing. We put it on the ballot, but we have to make sure that we don't put something in our ordinances that is against the law, which is what we have. So I think this is a good move for sure. I happen to know Gray Robinson law firm. We use them a lot at the hospital, and they're very competent to make sure this thing goes quickly and hopefully get an answer pretty quickly. Thank you, Mr. Mayor.
All right, people aren't taking their buttons off, but I think we're done. Member Nelson, you back?
I was back and I just wanted to say, to Richard's point, I actually had attorneys call me and say, what is this right to clean water? What does it do? So if the attorneys don't understand it, there's no way the lay people are going to.
I will say I was surprised there wasn't any explanation on the ballot of what it meant.
No.
And I don't know whose job that was or how that works. I didn't really know it was there like that until I went and voted, and I thought, wow, there's every other one of the amendments had some long, in some cases too long, but, an understanding of what it meant. So that was different. Again, I want to go back to our point of saying that we had an obligation in my mind to get it on the ballot. We did so 5-0. After that, it's out of our hands, and we'll go from there. You back, Vice Mayor? Are you still? Okay. Anybody else? No, sir. No. Take motion.
All right, Mr. Mayor and Council, I move that we accept and approve engagement letter from Attorney Leonard Collins of the Gray Robinson PA law firm, and allow our city attorney to sign the engagement letter.
Second.
And Mayor, I'd also like to confirm, we are taking the approach that language was misleading
Yes.
and should not have been on the ballot that way,
Right.
and that is preempted by law. And the judge will decide. We're not the judge, but that is the position.
All right. Any other comment before we go to vote? Oh, let me say, I have a motion from Vice Mayor, a second from Member Nelson. Roll call vote.
Member Nelson? Yes. Mayor Diesel?
Yes,
Vice Mayor Jordan?
Yes.
Member Stokel?
Yes.
Member Robinson?
Yes.
passes unanimously. City Manager, anything else?
Last is public comment.
Anybody from the public wish to speak?
She's
Any
shaking her
police
head back.
officers wish to speak?
Come on. Herman, you wanna speak?
Member-elect, you wish to speak? No, I'm not going to ask you to speak.
Please don't let him speak here.
All right, with that, I am correct in saying we shall adjourn the meeting and see you at the next event. Meeting adjourned.